Australian consumer law, we've looked at the definition of a consumer. We've also looked at Section 18, misleading or deceptive conduct. We've also then just looked at unconscionable conduct. The third area that we want to look at is consumer guarantees. Now, as we were saying, I think it was last week when we were looking at terms of conditions, there are express terms as part of a contract, there are implied terms, and then there are terms of a contract that are put in place by statute. And consumer guarantees are of that latter kind. They are guarantees for consumers about certain aspects of the goods that they purchase. This actually means that the seller of those goods can't put in a disclaimer or can't get around these particular guarantees that we're going to talk about. If you buy goods or services as a consumer, then you have these guarantees when you're going to purchase via the statute, via the statutes that make up Australian consumer law. What it comes down to is that the Australian consumer law provisions ensure that the goods and or services you buy are of a sufficient quality to do what they should be able to do. And there are three different elements when we're dealing with goods. The first is that they're of acceptable quality. The second is that they match their description. And the third is that they're fit for purpose. We'll talk about those in more detail. In terms of services, it's slightly different because you're not buying something, but it's the same kind of idea. If you get services, then they should be provided with reasonable care and skill, and that they should be fit for the disclosed purpose for which they were bought. And we can see the various sections that we have in place that form a basis for these laws. So let's go into some more detail. Here we have section 56, and 56 applies whether the person has actually seen the goods and examined the goods or not. So examination of the goods doesn't preclude this guarantee that they will match description. So what does this actually mean? And the example here is that if someone goes in to buy a DVD player and it's described as being an infrared remote control DVD player, but it turns out that the infrared remote control doesn't work, the function doesn't work as described, then the consumer has rights against the seller for breach of section 56, irrespective of whether they've actually seen it or not. The important thing to remember about section 56 is that it's dealing with the description, not with the quality of the goods in any way. If there's a problem with quality, we need to look at section 54, something we'll come to. But this is only whether the goods match the description. And a case to help us out with this is Ashington Piggeries and Christopher Hill. Okay, so what happened in Ashington Piggeries and Hill? So Hill was actually someone who made animal feed, and in this instance it was mink food. So food for minks, as we have down here, our picture of the mink. And Ashington Piggery was a farmer who farmed minks. And so they placed an order with Christopher Hill for some mink food. And actually, as part of that order, Ashington Piggeries, they not only did that, but they specified the feed. So they said what had to be in it. And what had to be in it was actually some herring meal. So there's my nice fish. So some ground down herring. And that herring came from a Norwegian company. And it was tainted. So in actual fact, the herring meal was off. And of course, that meant that the mink food contaminated. So the mink food's no good, and it killed a lot of the minks that the Ashington Piggeries had. And Ashington Piggery said, well, you know what, this didn't, they sued them for the equivalent of what was sale by description and said, you know, well, we asked for mink food. And what the court actually said here might sound a bit rough at first, But they actually said in terms of sale by description was no breach, because you actually got mink food to the order that you asked. It just so happened it was bad mink food. That goes to the quality of the goods, not the actual description. So here we need to discern the difference between something like a DVD player that's described as having an infrared function, and it doesn't have that. That means the description's wrong, versus something being described as mink food, which it actually was, but it had poor quality. So this section is specifically, section 56, is specifically about description, not quality. Section 55 deals with the case where when you're talking to the seller, when the buyer is talking to the seller and they say, hey, I'm planning to use these goods to do X, whatever X is. So I'm planning to buy this motor to put in my boat. Then this section actually says that where a person supplies in trade or commerce to a consumer, there's a guarantee that the goods are reasonably fit for the disclosed purpose, reasonably suitable for any purpose disclosed by the consumer to the business. So if you said, I want to use that motor in my boat, and they allow you to buy it, then it's implied that there's a guarantee that it will be fit to use for a boat. So if it wasn't marine grade and it broke, you could get an action under section 55. However, the exception to this is if you don't rely on the skill of the supplier when you disclose it. So if you don't rely on that supplier's skill, so just say they advise you not to use that engine, then section 55 won't apply. If they say, don't use that one, it's not marine grade, use this more expensive one, and you don't do that, then you won't have this action under section 55. So I hope you can see that. This has to do with the situation where the buyer goes to the seller, discloses what they're going to use the goods for. There's some form of recommendation, either explicit or implicit, by not saying don't use it for that, right? And provided that occurs, then there's an action under section 55 that the goods you bought should match that purpose that you disclosed to the supplier. The counterpart to this, of course, is that you have to disclose what you're going to use it for. You can't invoke a section 55 guarantee if you haven't said, I was going to use it on my boat. So there's this element about the negotiation or the sale involving you saying it's going to be used for a specific purpose, and if you do that, then it's implied into the contract that the goods should match that purpose. It should be fit for that purpose, unless, right, the seller says no, they're not going to be good for that purpose. Okay, acceptable quality, section 54, is kind of subtly, well, it's not even that subtly different. Whereas in section 55 we've dealt with the situation where you've made known to the seller what you're going to use it for. In this instance, it's saying, look, you don't even need to disclose things. If there's a normal use for some goods, if a toaster is used in a certain way, then anyone who sells a toaster should make sure that they're reasonably fit for the normal uses of a toaster. So let's have a look at the section in a little more detail. So acceptable quality involves definitions that are set out under section 54 subsection 2. And they include where goods should be fit for all the purposes for which goods of that kind are commonly supplied. So a toaster really needs to be able to toast bread, and probably muffins and fruit toast and, you know, the kinds of normal things you'd expect to put in a toaster. It has to be acceptable in appearance and finish. So yeah, it can't be all beaten up, and it can't be kind of ridiculously sticky or things. It has to be what you would expect a toaster to be. It's got to be free from defects, so you know the cord shouldn't be frayed, the knob shouldn't fall off, etc. The controls should work, particularly early on. You know, there's fair wear and tear, but when you take it out of the box, everything should work fairly well. It should be safe, so yeah, it shouldn't be dangerous, and sparks shouldn't be flying out, etc. And it should be durable, so that it should function for a reasonable time. So you can see here that it should be able to be used for most of the purposes that you'd normally use it for. It should look okay, there shouldn't be anything obviously wrong with it, it should be safe, and it should last for a reasonable amount of time. Now, of course, some things are cheaper than others. So you go, what's acceptable quality? Is it always the same? And as set out in section 54.3, the answer is no. The answer is acceptable quality will vary with the kinds of goods and the purchase decision that's involved. And in section 54.3, we see some of the things that you can take into account when you're working out whether something's of acceptable quality. They include the nature of the goods, the price of the goods, the statements made about the goods on packaging or labels, and representations made about the goods by the supplier during the sales process. So take our toaster example, right? You expect something like a fridge where you're paying hundreds or thousands of dollars to last a lot longer than a toaster where you might only pay $30, $40. You'd expect a top-of-the-line expensive toaster to last longer than a cheaper toaster. You'd expect that if the toaster says it can do something on the box, right, that it should be able to do that. And if you speak to the salesperson and they say the toaster can do something, you got a special crumb tray, then it should have that crumb tray. That's part of acceptable quality. Acceptable quality is by far the most all-encompassing one that most transactions get caught under, right? It means things must be of a reasonable and accepted quality. The case around this is McWilliams Wines and Leeuwenner. And in this case, McWilliams bought 500,000 corks from Leeuwenner. And a large number of them, when they were used to seal their wines, were contaminated. And so they weren't really fit for sale. Now notice, if we contrast this with our mink food case, that we can't get Leeuwenner here for a breach for sale by description because they are corks. But instead, they're not of merchantable or acceptable quality, as really corks can only be used to seal bottles to prevent contamination of the contents. That's the only thing they could reasonably be used for, and if they can't do that, then they're not acceptable quality. So part of what the McWilliams Wines and Leeuwenner case is actually providing us is insight, that it not only deals for things that are explicit, right? So when you make a representation under section 55, the fit for purpose, also we can imply that certain goods can only be used for one purpose, then they should be able to be used for that purpose. So a toaster needs to be able to toast bread. Corks need to be able to seal things. And what we find is that these terms and conditions, the acceptable quality term, is implied into the contract irrespective of what was actually said. You should note also that services are covered under the Australian consumer law. The two key sections for us are section 60. If a person supplies in trade or commerce services to a consumer, there's a guarantee that the services provided will be rendered with due care and skill. So you've got to pay attention and make sure people are competent when you're supplying services. And that if you supply services, they will be fit for the disclosed purpose. This is the equivalent of the earlier section around goods, and it applies for services as well. If a person supplies in trade or commerce services to a consumer, and the consumer makes known to the supplier any particular purpose for which the services are being acquired, there is a guarantee that the services and the product resulting from the services will be reasonably fit for that purpose. Same idea as the fit for purpose for goods. If there's a breach, if they don't meet those sections of the Act, the consumer has a right to remedies. They can claim a remedy from the supplier or the goods or services that includes a refund, a replacement, or a repair. Importantly, you can't exclude these sections of the Act. So section 64 prohibits the buyer and seller from agreeing to exclude the operation of the consumer guarantees. So you can't have in place a no refund policy. These signs won't work and they won't be considered a term of the contract. Things like no refund on sale items, exchange or credit note only, no refunds under 30 days. These are not valid under Australian consumer law. Similarly, for services, signs like no responsibility for loss or damage or goods left for repair at your own risk aren't actually valid or legal terms of a contract, as we would have discussed in